Morning, folks. You talk about going to Canada. I remember when I was first starting high school, people were going there to avoid the draft. I've never heard of somebody doing it to avoid finishing a jury trial, but I'm glad we got you back. First thing I want to do is thank, and this really comes from all of us, thank you for your service. Most of us are here because we choose to be here. This is our job, the police, the court personnel, the attorneys on the case. There's really only two people in a trial that normally don't have a choice to be here. One is the victims' families. And I can't think of a more difficult thing to not only remember what you went through, but to come into a courtroom and explain it to basically a group of strangers, to relive the worst moments of their life. But the next group is you. You know, you heard enough during the questioning. There's some key things you can say that if you wanted to get out of this, any one of you could. None of you did it, and we, again, appreciate your service. One of the first things you did on this case, and I talked about this once before, was raise your hand before the questioning and promise to tell the truth. And you all answered honestly that if we prove what we need to prove, you can sign a verdict calling for the death penalty. And we take you at your word. If we don't prove it, don't do it. And that's all we really have to go on at that point. And that was for all 120 of you were asked to do that. When it came down to you 16, there was a second oath. Will you follow the law as Judge Dinkelhocker gives it to you? You all said you would, and that's what we'll ask you to do now. What is the law in this case? You didn't have to sit through the first part of the case where we had 12 different charges against the defendant. Each had like 5 or 6 elements or pieces of it. It's really complicated. It's no easier than what you have to do, but it's a lot more complicated. At this part of the case, the law is pretty simple. You put on one side of the scale the aggravating circumstances the defendant was convicted of committing. And I'll go through those with you. That's here. On the other side of the scale, you put whatever mitigation you believe that they proved to you. And that's here. And you weigh them. And Judge Dinkelhocker will tell you, if you're convinced by proof beyond a reasonable doubt, and he'll explain what that means to you, that the aggravating circumstances outweigh the mitigating factors, and he'll even tell you what outweigh means. It just means to weigh more than. Even by the slightest degree, the bad things he did in this case outweigh even by the slightest degree the mitigation. You have to find for death, and you have to sign that verdict. It doesn't say you should consider it. You should give great deference to it. It says you shall sign such a verdict. And in the same way, if we don't prove that, if you believe they're even or the mitigation outweighs even a little bit, then you can't sign such a verdict. So that's really what you're going to go through at this point, weighing what the one weighs against the other. One of the things that I think you're going to be, what? Judge Dinkelhocker is going to tell you, you're going to have 16 different verdict forms. And you're probably thinking, why do we have 16 different verdict forms? Well, you only are going to be asked to sign 4 of them. There's 4 different charges of aggravated murder that the defendant was convicted of that you're considering. 2 for Ksenia, 2 for Esme. That's 4 different verdicts you're going to have to reach. But as he told you early on, you have 4 different choices on each one of those. One is the death penalty. And again, you have to give that if the aggravating outweighs the mitigating. If we don't prove that, then you choose one of the other 3 for each of these charges. Life without parole, life with parole eligibility in 30 years, life with parole eligibility in 25 years. What are the aggravating circumstances? First, let's talk about Ksenia. And when we talk about these people, you were shown a lot of pictures. This is the one we want you to remember her by. This is the only one we showed her grandma. This is the person we're talking about. Not that decaying, burnt, I don't know how you have to describe it, how he left her. Think of her that way. That's the person we're talking about here, Cassandra Crawford. What are the two aggravating circumstances he did to her and he was convicted of her? Well, one, the first jury found that he killed her while committing the crime of rape. A 14-year-old girl. You know, if she had been found earlier, the coroner could tell you a little bit more about her, like she could with Esme. She could tell you whether there were tears to her anus and her vagina, like there were on Esme. But he took care of that. They could give a better idea of her stage of development. Was she prepubescent, like Esme, or was she further developed? We don't know, because he purified her and then dumped the tires on her. But that is the first aggravating circumstance for the first count you're going to consider against the defendant. And there's one other word used in there that you haven't really heard before, and that he was the principal offender. And the reason that's in there is sometimes we have a crime where there's more than one defendant. You've got a bank robbery where somebody's shot, and you might have a getaway driver, and you might have a lookout, and you might have somebody else. And they can all be convicted of the same crime. But the only person in a case like that that could face the death penalty would be the person that actually pulled the trigger. So that language is in there because it has to be in there. But in this case, he's not only the principal offender, he's the only offender. So I don't want you to be confused about that. But that is one specification on that first count that you put on the scale, that he purposely killed her during the commission of the crime of rape. And there's a second specification for that count and for each of these counts, that he did it as part of a course of conduct where he killed 2 or more people. It's not called a serial murder, respect, but that's what it is in this case. Because he killed, and he killed, and he killed, and he killed 4 different women. You know, one of these you might be able to say, well, maybe something crazy was going on in his life that day, or maybe this, maybe that. 4 different innocent victims, 4 different families that will live with that the rest of their lives. That's the second specification that you put on the first murder charge you're going to decide, to be balanced against his mitigation. The second count, and actually the first one you consider, is count 2 in the first indictment. The second charge against him of aggravated murder was in count 4 of that indictment. Same basic facts, although he did this one while committing the crime of aggravated robbery. An aggravated robbery is seriously hurting someone while you're taking her property. And we know that because her grandma, Pat, told us that when she left that night before, she had a ring on her finger, she had a backpack, she had a phone. None of those were found. And that's what led the first jury to find that he committed aggravated robbery and he killed her while committing the aggravated robbery. And again, the second specification, that it was part of a course of conduct to kill 2 or more people. You know, the defendant's one expert, Dr. Van Aves, said 2 things that really kind of apply to all of these charges. Well, that first of all, he was in this dissociative state, which means that he had no idea what he was doing and no memory of what he did. And the simple question into that, you heard the great detail he gave the Cincinnati police detectives. If he had no memory of what he did and no knowledge of what he was doing, how did he have so much detail? There's nothing to back that up. And the second thing, even more preposterous, was this purification ritual. No, he wasn't destroying evidence. He was purifying their bodies. And one question I would have there is, why did he pick these girls clean of any valuables before he purified them? Because part of his motivation after he killed them was to take from their bodies any valuables he could scavenge. The third charge of aggravated murder you're going to consider is count 9 in the first indictment, the murder of Esme Kenny while committing the crime of rape. And again, just how we'd like you to remember Cassandra, this is how we'd like you to remember that young girl. Not that burnt, dismantled body that he left in the woods. This is the little girl, 4'10", 104 pounds, prepubescent. That's who he took care of on March the 9th. What are the specifications there? Again, they're the same. The first one, he did it while committing the crime of rape. And again, we would have the same details on Cassania had he not been able to do what he did to her. Had he completed Esme, we wouldn't have had those details. The tearing of the vagina, the tearing of the anus, the burning of the parts of evidence you could find on her that might leave his trace, her genital area and her hands. The defendant, in his statement, talked about she consented. She said, "You can do what you want, just don't hurt me." Her last moments on earth were looking up at him, tearing her little body as he entered her, pounding her fist on the ground. You know, maybe earlier she would have said, "Please don't hurt me." At this point, she's probably praying to God as the vomit filled her throat, "Please let me die." That's what he put that little...
There was an objection. Ladies and gentlemen, this is closing arguments, not evidence. We make the decision on what the evidence is. The objection's overruled.
That's what this little girl went through when he was committing the crime of rape against her. The physical evidence bears that out. And again, the same additional specification, he did this as the last part of this course of conduct where he killed 2 or more people. The final count, and as strange as this sounds, this is one that we're lucky he committed, the aggravated murder during the commission of the aggravated robbery. Again, he took any valuables he could get from her before leaving her behind, her iPhone and her watch. And I say we're lucky he did that because had he not taken those, when he was found in the park that night, before Esme was even found, they probably would have sent him on his way. And as soon as they cuffed him and searched him and found what he had in his pockets, totally changed this case. Sometimes you wonder if God intervenes in these kind of situations. That is what stopped this killing spree of Anthony Kirkland. And had he not had that little bit of greed that caused him to do that, he still may be out there. What is the mitigation? Well, again, Judge Dinkerlocker will tell you, you've got that, these 4 different counts with those various specifications. That's what you got on the one side of the scale to consider. He went over his girlfriend's house, Roberta Baldwin, and he was mad because he thought she was seeing somebody else, and he took his young, I don't know how old his son was at that point, 1 or 2 years old, and held him up and took a grilling fork and held it to his neck and threatened to kill him unless Roberta agreed to stop seeing anybody else. Well, the police were called. There was a SWAT standoff. He surrendered after about 30 minutes. And then Roberta did really not want to pursue the charges totally, but he did 4 or 5 months in jail on that charge, which took him to the fall of 2007. And again, this is in Gail Hellman's report. He was over another girlfriend's house, Sherry Lee, who had a 13-year-old daughter. 13-year-old daughter. And the defendant walks in her bedroom, naked from the waist down, offers her some money to have sex with him. She ran out of the house, told her mom, the police were called. He was charged with the crime of importuning and was convicted of that and did about a year in jail. So you wonder what happened to him in this little absence of time in between the first set of killings, which ended towards the end of 2006 with Kim Urolison, what he was doing in 2007 and 2008. He wasn't being a good boy. He was threatening to kill people and trying to have sex with little girls. He went to prison for a year and got out in late 2008. Several months later, he meets up with Esme. So that's the history, character, and background of the defendant. Does that in any way mitigate or say something good about what he did? That's up for you to decide. I think a reasonable judgment of it is absolutely not. Secondly, what were the nature and circumstances of the offense? And sometimes you hear the facts, and some people during voir dire said, I don't care if you take a life, I could never be on the case. And sometimes you hear the facts of a case and it's like, it's really pretty pathetic. And I remember one years ago, I don't want to go into many details, but it was actually a court reporter like Ann that worked in this courthouse that had I think most people agree, one of the nicest people we've ever met. And unbeknownst to all of us, he had a very, very sick wife who'd been bedridden for years and had become morbidly obese. And one day, her husband, this court reporter, went home and he couldn't stand her suffering anymore and put a pillow over her face and killed her. And he called the police and he said, this is who I am. Here's my address. I just killed my wife. I'm sitting on the front porch. I don't have any weapons. Please come and arrest me. And they did. And then he told him, I know my rights, but I want you to read them to me so there's no question you can use my statement, and gave a full confession. And he was prosecuted, and he went to jail for some time. And the only reason I bring it up, if you think of the nature and circumstances of the offense, that was the nature and circumstances of that offense. It doesn't justify what he did, but it's different than what he does. These were totally, totally, totally innocent victims. That could have been anybody that crossed his path. Cassandra crossed his path late night over there by Walnut Hills High School. Esme, only a couple hundred yards from her house in broad daylight. But they were little girls, and that's what he liked. The third, so that's, anyway, second thing you to consider are the nature and circumstances. And again, there's nothing about the facts of what he did, I think, in any way makes you feel sorry for him or mitigate what he did or explain what he did. And the third one, the last one for you to consider, is whether at the time, because of a mental disease or defect, he lacked the capacity to know what he was doing for wrong or refrain from doing it. Well, now it's time to bring in the experts. First, we've got Dr. Wu. And I've been doing this, gosh, I've been in the prosecutor's office. This is my 38th year. I've been doing this a long time. I know I look too young to be that old, but This is what I've done for a long time, and I've heard of experts like this forever. I've never personally seen someone that I would hold in less repute in an actual case of mine than him. I've heard of these guys. I've never.
Basis.
President, I do object that he is commenting on the veracity of
I believe I'm allowed to do that.
this person.
I'll withdraw, Judge.
You withdraw it?
Yes,
We'll do
fine.
that. That's fine, thank you.
You decide. Dr. Wu, a psychiatrist. What do we know about these mental exams of the defendant, Anthony Kirkland? When 2004 he had a bike accident, and all the medical records, and again, they're in there, it was a separated shoulder. No complaints of any head injury. 2007, he's in some type of minor car accident, and he goes to the ER. To be safe, they do a brain scan. And if there's anybody who wants to make sure there's no trauma, it's a situation like that, because if these doctors get it wrong, they're going to get sued. And what do they say? No brain trauma, totally normal. In 2009, he's in a fight, and he goes to the ER. And again, there's a brain scan, and guess what? No damage, totally normal. In 2017, Dr. Wu gets involved. He can't do brain scans. He's not qualified. He's a psychiatrist. But he asked for brain scans to be done. And he goes to the OSU Medical Center where two different types of scans are done. Dr. Wright does something called a PET scan. Dr. Bolter does an MRI. Both, we find out later, are normal. Why do we find out later? Because it's interesting. Dr. Wu is asking these radiologists to give these exams, but he tells at least the one, Dr. Bolter, I don't want you to interpret it. He doesn't want him to interpret it because he doesn't want anything in writing saying it's normal. He wants to do that. Don't interpret it. A radiologist that does this for a living, given the x-ray, I'll say what it means. Incredible. We also have Dr. Waxman, who came in here live, who's testified against Dr. Wu on a number of occasions. He says, perfectly normal. In fact, he explains Wu's methodology. And we can't see inside my head, but I'll use my hand as an example. I think it's a normal hand, nothing special about it. I got a thumb and a pinky and 3 fingers in between, and it's got scars and cuts like everybody else has on our hands. It would normally be considered a normal hand. Wu took 70-something people that had normal brains and did his own little study, got scans done of them. And any one of them would have been normal. But then what he does, he combines them all and makes a perfect brain. And that's what he uses when he does these brain scans. Unless you match that perfect brain, you're not normal. And Dr. Waxman's studied this guy because it bothers him. They're in the same field. He doesn't like people doing this. He says he has found 1,000 cases where Wu has done a brain scan and he could only find one that Wu said was normal. Dr. Wu himself, when Mr. Gibson cross-examined him, just name me one. Name one person you've done a brain scan on that came back normal. He couldn't do it because that's not what he's paid to do. Most of his work is on civil cases, which he said, and I'm sure he has people in these small accidents that have him do a brain scan. They give him a report from Dr. Wu saying he's got brain damage, and now they're going to talk settlement. That's their one expert. Put whatever weight you think is appropriate on him. The second expert, Dr. Van Aes. And I look at her differently than Dr. Wu. I think she is an honest person. I think she's sincere. I think for whatever reason she lost her way on this case. In her report, she lists what she relied on. As far as brain scans, she said, I got the report from Dr. Wu. And I asked her, well, what about what you weren't given? The 2007 emergency room scan that said he was normal, the 2009 emergency room scan that said he was normal, the 2 scans done in 2017 by Dr. Wolter and Dr. Wright that said he's normal, and Dr. Waxman's report. Did you look at those? No. Does that change your opinion? No. That right there, again, it's for you to decide, but she says she'll keep her mind open if given new information, but how can you rely on Dr. Wu, a psychiatrist, when you have 4 radiologists and a fellow psychiatrist all say there's no brain damage? But the reason she does, because she needs some kind of trauma, because her expertise is post-traumatic stress disorder. You can't have it if there's no trauma he suffered. So in order for her to even get to the beginning of her work, she needs somebody to say, he's got this brain damage. Well, Dr. Wu provides that. So what else was she given? She was given summaries of the family interviews. In those interviews, not a single one of them said a single word about Anthony Kirkland being abused. Not a single one. His brother, his sisters, his mom, none of them said anything like that happened to Anthony. Well, she disregards that and relies on what he tells her. There's no police reports to back any of this up. There's no hospital records. There's no school records saying Anthony came to school again today black and blue. None of that, because it doesn't exist. She's given the mental reports, the prior mental reports. Now, if there's anything she's going to respect, it ought to be these fellow professionals of her. She's given the report of Dr. Gail Hellman that says he's got antisocial personality disorder. That's not a mental disease or defect. It's a way of describing someone that has the characteristics that he has. She's not given the 2010 report of Dr. Bressler, 2011 report of Dr. Eschbaugh. All say the same thing. He's antisocial. Disregards those. She's also not given the report of Dr. Hawkins just a couple months ago that doesn't say what he does have, but the one thing he says he doesn't have is post-traumatic stress syndrome. He says he has none of the characteristics of that. So again, we asked Dr. Van Aes, you said at the beginning of your report, if we provide you new information, you said you reserve the right to change it. And when provided all that new information that she acknowledged she did not consider earlier, and no police reports to back any of this up, anything else, she says, no, it doesn't change it. In fact, I asked her, is there anything we could give you that would change your mind? Nope. That's the mitigation. And finally, his unsworn statement, which the judge told you he's permitted to stand up, not be asked questions by his attorneys, not be asked any questions from us, give his unsworn statement, which he read to you. I don't know if he wrote it or not, it doesn't matter. But that is what you put on the other side of the scale. Dr. Wu, Dr. Van Aes, his unsworn statement. And for you to not sign a verdict of death, you're going to have to find that, I'm sorry, Esme and Consania, what he did to you, but this, what he presented to us, balances the scale. One last thing I'd just like to comment on. In voir dire, the defense put a lot of emphasis on a lone juror. Any one of you can stop this from happening. And that's true. But I would ask that when you go back to deliberate, your goal should not be to split apart. It's to find a unanimous verdict. And if you find yourself back in the jury room and it's 10-2 or 11-1, and you find yourself in a minority, I just ask that you ask yourself, Why is my opinion so different from everyone's else? If you honestly believe that the state of evidence is such that what he showed you to mitigate what he did balances the horribleness of what he did, then don't give up that verdict. You should never sign a verdict you don't believe in. But I believe if you really look at this case and follow the law, there can be only one verdict for each of these 4 counts, and that is a verdict of death. And that's what I'm asking you for.